I'm often asked how a DUI and the driver's license suspension relates to the criminal case. In essence, when you're arrested for DUI, it's like you get two cases. You have the driver's license division on one side, which is a civil administrative proceeding. On the other side, you have the criminal charge in court. In essence, these two things are completely unrelated, separate actions. On the driver's license side, because it is a civil administrative hearing, the only penalties that can be imposed are suspension on your ability to drive, restrictions on your future ability to drive, such as ignition or alcohol restrictions, and the charging of fees. On the criminal side of the case, you're facing the crime and the penalties associated with that, including jail, fines, community service, counseling, probation, and the list goes on from there. These two offenses, or these two cases, are completely unrelated. In essence, one does not dominate the other. At the administrative level, you can lose your driver's license hearing, but still defend and prevail and get your case dismissed on the criminal side. Vice versa, you can win the driver's license hearing and still get convicted in court. So in essence, one does not dominate the other. The only way these two separate cases are in any way related is if you suffer an administrative suspension on a first offense of 120 days, and you can show proof that the criminal charge was either reduced or dismissed prior to the end of the 120-day suspension. Upon proof to the driver's license division, you will be allowed to reinstate your license as early as 60 days. So in essence, you can cut your driver's license suspension in half. The other way that they're potentially related is if we can get you past the driver's license division administrative process without a suspension, and you can get your criminal charge reduced or dismissed to something less than a DUI, those convictions may be reported to the driver's license division, so they will not trigger a suspension. In essence, what that means is there's two ways for you to lose your license. Once at the administrative level and potentially again on the criminal case. You will not be subject to a double suspension, meaning that if you serve 120 days on the administrative side, get convicted, you're not going to serve 120 additional days of suspension because there's a statute that requires that you be given credit for this suspension towards the administrative one you've already served. However, there is a provision in Utah law that under whatever circumstances the judge deems are appropriate, the judge can order an additional suspension of driving privileges over and above what was imposed administratively or based on the conviction. So in essence, in order to save your driving privileges, you not only have to prevail at the driver's license division administrative level, but you have to have your criminal charge reduced or dismissed something less than a DUI.